everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is a continuation of the ongoing series of the changes that the Georgia Association of Realtors, or GAR, made to the 2022 contract package. And today we are going to cover the changes they made to the exclusive buyer brokerage agreement, which is GAR form F110. Probably the most changes have been made to this document than any other document in the package this year. So I'm going to go over what the changes are, and we're going to have a good discussion about why some of these changes were made and what that means for you as an agent in practice working with a buyer client. So the first change they made has to do with a little bit of clarification on the buyer's consent to dual agency. I've covered that in the listing changes to the seller brokerage agreement, so check on that. Basically, it's if your broker offers dual agency, there is a place where the buyer may consent or does not consent to you as an agent practicing dual agency with this particular buyer. But the biggest changes they made has to do with the commission section. So those changes are on paragraph, and they've reformatted some things too, but have to do with paragraph A4 and the corresponding further explanation paragraph B4. So sit back, relax, enjoy. Let's have a good discussion about this. So it's all new formatting and all new verbiage. And I'm going to read it to you, and then I'll summarize them. We'll talk about why these changes took place. So the buyer's commission obligations in purchasing real property is paragraph 4A, A4A. Buyer agrees to pay broker the commission set forth below at the closing of a contract to purchase, as that term is herein defined, entered into during the term of this agreement, minus any commission paid to the broker by either the seller's broker or the seller. Buyer acknowledges that the commission, if any, being offered by the seller's broker is usually set forth in the multiple listing service in which the property may be listed. And then it has subparagraph A4B commission. And it's those check boxes that have either a blank percent of the sale price, a flat dollar amount, or other. Then we'll come back to a good discussion on this. Then they have a section on 4C, separate commission on leases. And if you have been a Maximum One agent, you know we have had a special stipulation to this effect for a long time that there would be a separate commission paid on a lease. But GAR has added this into the buyer brokerage agreement. So thank you so much, GAR. And it states separate commission on lease. If buyer leases property or enters into a lease purchase contract or a lease with an option to purchase agreement during this agreement, buyer shall also pay the broker a separate leasing commission, except where commission is paid by the landlord in the amount of blank and as follows. And there's a fill in the blank. Notwithstanding any provision of the contract contained herein, the payment of a leasing commission, including lease purchase transactions or lease with an option to purchase, shall not relieve the buyer from paying a commission at the closing of a contract to purchase as provided herein in this agreement. And then the protected period, they've moved under the commission statement. Because what are you protecting? You're protecting your commission. So it says the length of the protected period shall be blank number of days. All right. Then they have the explanatory paragraph where they've redone everything. And under B4, commission, A, buyer's commission obligation in purchasing real property. And it states, this is the further explanation of the fill in the blanks, what your broker negotiated with the buyer regarding commission that a buyer is obligated to pay for your services as a real estate professional. The obligation of the buyer to pay the broker the commission shall be offset by any commission paid to broker by either the seller's broker or the seller. Buyer's commission obligation shall exist even in the closing of the transaction occurs after the time of this agreement has expired. Buyer shall additionally be responsible for paying the commission if the buyer defaults under this agreement or if the buyer enters into a contract of purchase during the protected period on certain properties as explained in the protected period section below. So basically what has happened, from the explanation part, GAR has removed the verbiage that says the seller normally pays the commission. And what they have changed, if you'll remember from last year's and previous year's buyer brokerage agreement where it talked about commission, it always had a fill in the blank, buyer to pay buyer's broker either a blank percent of the sale price or a flat fee or other. And then it had subparagraph B, and it said, it did say that the seller usually pays the commission, and if not, the buyer shall or shall not pay the difference. They've taken all of that verbiage out. And in essence, it has become, with the 2022 version of the buyer brokerage agreement, commission is now a buyer obligation to pay versus a buyer choice to pay. And they also add a reference to the seller side commission, the seller side paid commission as disclosed in the MLS service. And they've added commission on a lease. And again, as I said, added the protection period. So why all these changes? What is going on? Well, there have been a lot of issues, a couple-fold. One has to do with the market, and we are finding that there are a lot of sellers, a lot of listing brokers that are not paying a buyer's broker's commission. Yet what you do working with a buyer is of good and valuable service from you as a professional real estate agent. Additionally, there is a big old huge lawsuit going on that has been going on between the Department of Justice and the National Association of Realtors. It's an antitrust lawsuit, and it's very interesting. I'm not an attorney. I am a broker. There's a lot of information about it online and through the National Association of Realtors. But in essence, GAR is taking a proactive step in the buyer brokerage agreement with respect to potential outcomes of this lawsuit. So what happened was, basically in November of 2020, the Department of Justice sued NAR regarding their MLS policies regarding disclosure of commission. And it was a whole antitrust, they're claiming it against the Sherman Antitrust Act. And basically, it bottom line boils down to everybody in a real estate transaction knows how much a buyer's broker is going to get, except for the buyer. There was also agents marketing themselves that a buyer's agent, if you are a buyer of real property, then the services of a real estate professional are free. There's no cost to you if you are the buyer side of a deal. Do not use that verbiage. And that is part of this lawsuit between the Department of Justice and NAR regarding antitrust issues and pay and disclosure and transparency and so forth and so on. Additionally, there were some brokers in certain parts of the country and even in Georgia, there are certain MLSs that have the lockbox on a house is based on the MLS in which that property is listed. And so brokers were limiting access to lockboxes to members of NAR that were only affiliated with that MLS and not letting agents with a lockbox not affiliated with that MLS see those properties. Anyway, this lawsuit was settled out of court. NAR agreed to change some of their policies and disclose to buyers the offer of commission that the seller's broker was offering to pay the buyer's broker. Settled out of court, good to go, policies changed, clear cooperation. we here in Metro Atlanta have seen a lot of the impact of that in our MLS systems and some of the rules and procedures there based on the NAR Clear Cooperation Policy. However, in July of 2021, the Department of Justice pulled out of the settlement agreement, completely unprecedented, to basically vacate their position in a settlement agreement. And so, and said they needed to do more to expand their investigation. So in September of 2021, NAR countersued the Department of Justice for their unprecedented action of vacating or abandoning their position in this settlement. As of October of 2021, the DOJ has stated that they will continue to expand their investigation. So stay tuned. This is not over yet. Again, there's a lot of information online through NAR. It is just an interesting lawsuit. But nevertheless, back to the topic at hand, GAR, in anticipation of what's going on, plus what did come out in the settlement agreement that has now been abandoned by the DOJ, but nevertheless, NAR does have some policy changes, and so GAR is taking steps to address those changes proactively, which is why it now states under the commission, under the buyer brokerage agreement, they took out the word the seller normally pays or the listing broker normally pays, and it is an obligation for a buyer to pay the buyer's broker. However, that amount is offset by the amount of commission the buyer's broker receives from the seller's broker or the seller. So big change, and that is the biggest change, but that is why. So, and again, broker tip, point in practice, never tout your services saying that what you do is free to a buyer, that there's no cost to a buyer. All right. Now, they have also added, moving along, we're still in the buyer brokerage agreement, F110. Oh, before I go back to that, you will probably see coming up in the near future some rules or regulations, perhaps some legislation, but definitely some rules and regulations about disclosing what the buyer's broker commission in any and all marketing and advertising of properties. And you have noticed Redfin has actually already taken a stance on this. And again, this has to do with these issues that we have been talking about. And Redfin has absolutely already announced that they are now publishing agent commissions on all of their listings. So that is all tied in to everything that we have been discussing. All right, now moving along. Under the section under miscellaneous, so this is paragraph C7, they've added a whole new paragraph, again, based on the market that we are, the climate of the real estate market in which we currently are in, and this is December of 2021, and the section is buyer buying a property sight unseen. Broker hereby advises buyer that there are significant risks in buying property sight unseen, since pictures, videos, and other information about the property may not accurately reflect the true nature and condition of the property or area in which the property is located. Therefore, if a buyer purchases the property sight unseen, buyer agrees to indemnify and hold broker harmless from any and all claims, suits, damages arising out of or relating to any issue that buyer and buyer's representatives other than the buyer's broker would have reasonably observed had the buyer visited the property and surrounding area. Again, that is just a protection because of the market we are in. Then they have a new paragraph, again, under miscellaneous, C7F, definition of buyer and seller. The verbiage is not new. It's just a reorganization. The definition of a buyer and seller used to be defined under the protection period, and it was all in there, but they've just moved it under this miscellaneous section. Then, consistent with the listing agreement, actually back in April of last year, in the mid-year change that GAR did, under the referral section, they added builder, that When a buyer signs the buyer brokerage agreement to stay in compliance with a license law on unfair trade practices, they have added in that the buyer, the public buyer, does give the broker / affiliated licensee authorization to refer them to not only another real estate broker, but also to a builder. And that is in the listing agreement as well. Then under the buyer default section, this section is definitely expanded, and the verbiage has been reworded a little bit, and a lot of information added. Some of this information was added in April of last year during the mid-year change, and then there is a whole new section. Again, this is under buyer default in the buyer brokerage agreement, paragraph C8. And basically, they've added that if the buyer defaults, notwithstanding any provision to the contrary, the buyer agrees to immediately pay the broker its commission or unpaid portion thereof. So they've added that if partial payment has been made, the buyer is obligated to pay the remainder in the event the following shall occur. This part's been the same. Buyer defaults. The general buyer defaults under contract to purchase real estate under which the broker would have been paid its commission had the transaction closed. That's not a change. Then in April of last year, the mid-year GAR change, they add buyer agrees with the seller. This also is part of what constitutes a buyer default. If the buyer agrees with the seller to mutually terminate a contract to purchase under which the broker would have been paid its commission had the transaction closed without the prior consent of the broker, except if the mutual termination is during the due diligence period or any other contingency under which the buyer did have the obligation to terminate the contract for any or no reason to do so. And then there's a section if the buyer unilaterally terminates. This part has not been changed. Buyer unilaterally terminates this agreement and then enters into a contract to purchase property, lease purchase, or lease option as applicable either during what would have been the remaining term of this agreement had the agreement not been unilaterally terminated or during the protection period as it's defined. What that part means in essence is you can always be fired. A buyer can fire you, but you can only be fired from representation, not necessarily from compensation. So a unilateral termination of a buyer brokerage agreement does constitute a default of the buyer exclusive buyer brokerage engagement agreement. So again, they don't have to go with your representation in a contract for real property, but so again, you could be fired for representation, but not necessarily compensation. A unilateral termination does not alleviate the buyer from their obligation to pay the commission owed if that transaction closes. And then a whole new paragraph C8D, new subparagraph. Buyer enters into a contract to purchase real property during the term of this agreement and later closes on the same, even if the closing is after the expiration of this agreement, where the broker is not paid its entire commission. So again, they've expanded the definition of what constitutes a buyer default. And the biggest change, however, does have to do with that commission section and the rewording of that. If you have any questions on that, I absolutely encourage you to have a good discussion with your broker and your broker's policies, making sure that you are in compliance with, if you're a realtor, with NAR, even if you are not a realtor, with your membership agreement to the MLS services, which is all tied in to this, as well as just in general, making sure that you are not in violation of any potential antitrust issues regarding commissions, prices, showing properties, so forth and so on. Whew. We do continue to teach CE classes on the 2022 Georgia Association of Realtors Contract Changes. I will link the calendar below. We have many of those classes. They are hosted by Maximum One companies throughout Metro Atlanta. Many of them are actually in the physical locations of Maximum One or virtually, and I will link all that information below. Thank you guys so much for watching. Dana Sparks. Stay tuned for more videos on the 2022 GAR contract changes. Woo! Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.